Welcome back to the Deep Dive. You are listening to the WeCyberYou Unlocked podcast.
And just to be absolutely clear for those new to the show, that is WeCyberYou.
WeCyberYou. Got it. And we're really glad to have you with us for this one.
It is great to be here. And honestly, if you find value in these discussions, or if you're looking to sharpen that edge in your professional toolkit, do yourself a favor and follow the channel right now.
Yeah, definitely a follow.
And for even more educational cybersecurity content like this, head over to WeCyberYou.com.
You really should check out WeCyberYou.com. But let's get right into the meat of today's session. We are taking a trip down south to Argentina.
Yes, we are.
Now, usually when we talk about privacy legislation, the conversation starts and ends with the GDPR in Europe.
Right, or maybe the CCPA in California.
Exactly. But today we are looking at something that predates a lot of the modern privacy discourse. We're breaking down Argentina's personal data protection framework, specifically Law Now,
Right.
25,326.
It's such a fascinating case study. And what makes it stand out isn't just the content of the law, but the timeline.
That's the very first thing that jumped out at me during the research.
Yeah.
This law was enacted in the year 2000.
Yeah.
To put that in perspective for everyone listening, the year 2000 was the height of the dot-com bubble. We were all just recovering from the Y2K scare.
Barely recovering.
Right. I mean, Facebook didn't exist. The iPhone was still 7 years away.
Hmm.
And yet, here is Argentina laying down this comprehensive privacy framework that looks, well, it looks surprisingly modern.
It was incredibly forward-thinking. You have to remember at that time, most of the world was treating the internet like the Wild West.
Oh, absolutely.
Data was really just a byproduct of a digital interaction. It wasn't an asset class or a major liability yet.
Mm-hmm.
But Argentina recognized very early on that data protection was going to be a fundamental right in the digital age.
They weren't just reacting to a data breach scandal.
No, they were setting a foundation. And really the mission of our deep dive today is to understand how Argentina set that standard for privacy in Latin America.
And why the European Union treats them so differently than many other nations.
Exactly. Because that foundation had a very specific strategic goal. It wasn't only about protecting citizens, there was a geopolitical and economic play here too. We really need to talk about the European connection.
That European connection is huge.
It's the key to understanding why this law exists in the form it does. Argentina wanted to do business with Europe. They saw the direction the European Union was heading with its data protection directive.
Which was the predecessor to the GDPR.
Right. And they realized that if they wanted to be a hub for outsourcing, for software development and business services, they needed to speak the exact same regulatory language as the EU.
And that effort completely paid off.
Yeah.
Because Argentina holds a status that is actually quite rare in the global landscape. They are considered to provide an adequate level of data protection by the EU.
That is a major badge of honor. It's the golden ticket.
Because adequacy is a massive deal, right?
It really is. It basically means the European Commission has looked at Argentina's law 25,326 and said, your standards are essentially equivalent to ours.
Which opens the doors for business.
Completely. It allows data to flow freely between the EU and Argentina without needing all those complex legal workarounds. You don't need standard contractual clauses for every single transfer.
Which gives them a huge competitive advantage. I mean, look at the struggles U.S. companies have had with things like Safe Harbor and Privacy Shield getting struck down.
Yeah, it's been a mess for the U.S.
Meanwhile, Argentina has just been sitting in the Safe Club for over 2 decades. And this law applies across the board, right? Both public and private organizations.
That's right. So whether you're dealing with government records or a private bank processing data locally, the standard is uniform.
So let's get into the mechanics of the law itself, because we know it covers personal data. But in the context of the year 2000, that definition must have been pretty interesting. How does the law define what we're actually protecting?
The definition is surprisingly robust. It covers any information of any kind that can be used to identify a person, whether directly or indirectly.
So the usual suspects.
Right, the standard identifiers: name, ID number, address, email. But they also specifically call out professional categories like financial data and employment data.
And didn't they include online identifiers too?
They did, and that's the impressive part. Even back in 2000, the law was written broadly enough to encompass online identifiers.
That just strikes me as incredibly sophisticated. Because in 2000, online identifiers basically meant cookies and IP addresses, but nobody was regulating them. The whole ad tech ecosystem hadn't really exploded yet.
Not at all.
By including that, they effectively future-proofed the law for a good decade or two.
They really did. But the law also draws a very hard line when it comes to a specific subset of information. They created a distinct category for sensitive data.
Ah, the high voltage category.
Yeah.
This is the data that makes compliance officers sweat.
With very good reason. Sensitive data under this framework is subject to much stricter protection rules.
What falls under that umbrella?
We're talking about health information, biometric data.
Wait, biometrics in the year 2000? Like fingerprints and facial recognition?
Yeah, and they saw it coming. It also includes racial or ethnic origin and political or religious beliefs.
I think it's worth pausing on the political and religious beliefs part. In the U.S., we focus so heavily on financial data, credit cards and social security numbers.
Right.
But in Latin America, and specifically Argentina, there is a intense historical context for why political data is considered so dangerous.
That is a very astute observation. You have to look at the history of the region. Argentina, like many Latin American countries, had gone through periods of military dictatorship.
Right, where lists of people were weaponized.
Exactly. Profiles of their political affiliations or even student activities were used for persecution. So this law isn't just about preventing identity theft. It's actively about preventing profiling that could lead to discrimination or human rights violations.
So treating sensitive data with those strict rules isn't just a bureaucratic hurdle, it's a fundamental safeguard for civil liberty.
That is the core philosophy.
That's fascinating. And that brings us perfectly to the power of the individual, what the law calls the data subject. In the modern security landscape, we're very used to user rights.
Oh yeah, everyone knows about DSARs now because of GDPR.
Right, data subject access requests. Did Argentina really have this dialed in back then?
They absolutely did. The law grants a very strong rights framework that gives the individual serious agency over their own information.
Let's walk through those rights. Because for a listener who's maybe running a security program, these rights translate directly into operational requirements.
First and foremost is the right of access. Any individual can approach an organization and ask, what data do you hold on me and why are you holding it?
And operationally, that is a heavy lift. If you have data scattered across 6 different legacy systems, just responding to that one request is a total nightmare.
It forces organizations to have good data hygiene. You can't be transparent if you don't know where your own data lives.
Very true. What's next?
Then we have the right to rectification. If the data they hold on you is wrong, you have the right to force them to correct it.
Which is crucial for things like credit scoring or background checks.
Exactly. If a database says you defaulted on a loan you never took out, you have a legal mechanism to fix it.
And then there's the big one, the right that arguably causes the most friction for data hoarders, the right to deletion.
Yes, the right to request data removal when it is no longer needed.
This is effectively the right to be forgotten, long before that famous Google Spain case made international headlines.
It's very similar. It's grounded in the idea that if a company doesn't have a valid, ongoing legal reason to hold your information, you can demand they destroy it.
And there are a couple more, right? The right to confidentiality?
Yes, the basic right to keeping data private, and also the right to object.
How's that one work?
Yeah, it's the ability to say no to certain processing activities, like opting out of having your data used for direct marketing. It really shifts the power dynamic back to the user.
So we have a law that establishes incredibly strong individual rights. But rights are only as good as the obligations placed on the companies holding the data.
Exactly.
So if I'm a CIO operating on Argentina, what are my rules of the game?
The law outlines several organizational obligations. The first is about data collection and hygiene. Organizations must collect data lawfully and fairly.
This is not tricking people.
Right. And that ties directly into use limitation. Data can only be used for specific and legitimate purposes.
I use the pizza shop analogy a lot for this. If I give you my phone number so you can call me when the pizza arrives, and then you use it to text me coupons 3 months later.
You've violated the use limitation.
Because you repurposed the data without my consent.
Exactly. And the law also mandates quality control. Organizations are obligated to keep the data accurate and up to date.
Now, let's talk about security and registration. Because all the policy in the world doesn't matter if the server is left wide open to the internet.
No, it doesn't. The law requires organizations to implement security measures to prevent unauthorized access or breaches.
But there is a specific bureaucratic requirement here that feels a bit unique compared to the U.S., right?
Yes, there is a registration requirement. Organizations must actually register their databases with the Argentine Data Protection Authority.
Wait, to be clear, they aren't uploading the actual data to the government, are they? Like, they aren't sending a spreadsheet of customer names and emails?
No, they aren't uploading the content. They are registering the existence of the database.
Oh,
They file a declaration basically saying, we have a customer database, it contains these specific categories of data, and we use it for these purposes.
So it creates a national registry of data processing activities.
Exactly. It adds a major layer of accountability.
And what's the baseline rule for collecting all this in the first place? Consent.
Yes. The general rule is that clear consent must be obtained from the individual unless a specific legal exception applies.
Okay, so that covers the internal rules. But what about borders? Data doesn't stay within national borders anymore. It sits in the cloud. It gets replicated to servers in Virginia or Dublin. How does a law from 2000 handle international transfers?
Well, this is where that EU influence comes back into play. The general restriction is that data can only be transferred abroad if the receiving country ensures an adequate level of protection.
So if I'm an Argentine company and I want to use a cloud provider based in a country that's considered a privacy Wild West, the default answer is just no.
The default is absolutely no. You can't just export the data to circumvent the law.
But business still has to happen, so what's the exception?
If the destination country doesn't have that adequate status, transfers are only allowed if specific safeguards are in place.
Like what?
Like specific legal contracts that guarantee Argentine standards will be met, or if you get explicit consent from the user for that specific transfer.
So the protection travels with the data.
That's the entire point.
Let's talk about the enforcers. Who is the watchdog making sure all of this actually happens?
That would be the Argentine Data Protection Authority.
Do they actually have teeth? Or are they just issuing sternly worded letters?
No, they have teeth. Their powers are quite extensive.
What can they do?
Well, they can issue warnings, obviously, but they can also impose significant fines.
Fines are standard. But is there a bigger stick they carry?
There is. They have the power to suspend or completely close databases.
Whoa. The nuclear option.
Yeah, literally stopping a business in its tracks. Imagine telling a modern digital company they're legally forbidden from accessing their own customer database.
That's an existential risk.
And for the most serious cases, particularly where there is malicious intent, they can refer cases for criminal prosecution.
So jail time is on the table. It is incredibly clear that this law was not just a token gesture. Law 25,326 really set a high standard for privacy protection in Latin America.
It really did. And its significance today is huge. It influences newer reforms across the region.
It's absolutely critical for any organization handling international data flows, and it really protects individuals against misuse and profiling.
It's a foundational text for global privacy.
Well, as we wrap up this deep dive, I want to remind everyone listening that this has been the WeCyberYou Unlocked podcast. That is WeCyberYou.
And please, if you haven't already, go follow the channel right now. And visit WeCyberYou.com for more deep dives and educational content just like this.
Open a tab right now and go to WeCyberYou.com. But before we sign off, we like to leave you with a little something to think about. A provocative closing thought.
We spent some time discussing the right to deletion today. The idea that you can tell an organization to just erase you?
Which sounds so simple on paper.
It does, but think about the reality of our digital footprints today. If you requested to have all your personal data deleted today from a major tech company,
Right.
Do you think those organizations are actually organized enough to find every single piece of it?
That is a wild thought. Because your data isn't just in one neat little row in a database anymore.
No, it's in backups, it's in data lakes used to train AI, it's sitting in cold storage.
So the question is, if you ask to be deleted, are you ever truly gone?
Or is there a ghost of your data sitting on a server somewhere that they just couldn't find?
That is definitely something for you to mull over. Thanks for joining us on this deep dive, everyone.
Bye.